Welcome to today's webinar, courtesy of the Kentucky Small Business Development Center in Louisville. Discover no-cost, valuable business services to help you thrive, whether starting your entrepreneurial journey or scaling your existing business. We have the resources and expertise to help you succeed. For more information, please visit our website or text 502-977-5800. Thank you for joining us today. Feel free to use the chat feature to ask questions or engage with our speaker. Let's get started.
Hey, welcome everyone. Welcome to another Toolkit Tuesday. I'm Dave Etkin. I'm the director here at the Louisville Small Business Development Center. As always, I'm joined by my good friend and colleague, Janet Flaw. Janet, how are you today?
I'm good. It's a gray day, but it's okay. We're into
Yeah.
May now, so that's fabulous.
And also, this is Small Business Week. We've been celebrating small businesses all week long, so hope you are too, because they're important. And just to pile on top of that, we work with small businesses every day, and we have a lot of resources, expertise. So please reach out to us. We're here to help. We want to see you succeed. We want to see you grow, and do all the things that you need to do to make your business the success you want it to be. So, and as always, just to make sure that you can see in here. So if you look at the bottom of your screen, you should be able to see a toolbar. If you don't, just kind of hover at the bottom there, and it should pop right up. And there you'll see the chat feature. And if you wouldn't mind just putting, saying hello, tell me your name and where you're joining from, so that I know there's somebody out there. I can see you guys kind of popping in, but I never know what happens. We have issues every now and then, so it's good. It's good practice to see where everybody's popping in from. Hey, Tom, good to see you. Tom Sandlin is a local artist, very talented man. There's Janet. She's in our Sellersburg office. And Aprila from Louisville, good to see you. Let's see, the people are popping in, so please just say hello and tell us where you're joining from. Make sure that that you're connected. There's Drew. Hi, Drew. Hey, Dave. Dave from Louisville. Danville. For some of our usual AI assistants. Hello, AI folks. Just to make sure that say hello. So anyway, thanks for joining us today on another Toolkit Tuesday. Happy you guys are here. I personally get a lot of questions when I'm working with people setting up their business or launching new product line. Tons of questions about how do I protect my intellectual property? How do I trademark this or that? And not being an attorney, I have limited experience in this field. So I thought it was wise if we just brought in an expert to talk a little bit about the do's and don'ts, the best practices. And so I've invited my good friend and attorney, Jeremy Beck, who is a longtime intellectual property attorney. And so here's an opportunity for you to ask those specific questions that you may have about your business and your trademarks, your intellectual property, your logo. So when you have a question, just put it in the chat or a comment or whatever, and I'll be watching the chat, and we'll be able to talk to Jeremy as long as we need to. So here's a great opportunity. Don't pass it up. So Jeremy, welcome. Good to see you today.
Thank you. Good to be here.
Yeah. So Jeremy is going to jump in here and explain a lot of the questions that you have about trademarks and how to protect your business, because there is a ton of theft out there. So, Jeremy, I'm going to turn it over to you, and let's just get started.
Yep, sounds good. So before getting into some of the specifics about trademarks, I like to just look through the differences between trademark and copyright, because sometimes that comes up where folks are maybe not exactly sure of the difference between the two. So moving forward, trademark and copyright protect different types of work. So trademark, we're focused on words, symbols, logos that distinguishes the source of your goods or services. Whereas with copyright, we're talking about documents. It could be artistic works, literary works, photos, films, anything like that, creative works, not necessarily associated with your business. Neither of these requires actual registration, but you acquire more rights through registration. Continuing to look at some of these differences. So trademark requires actual use. So you can't come up with a design for a product or a business and then you just sit on it for a while. You have to actually use it in commerce in order to have trademark rights. Whereas with copyright, that comes into being the moment of creation, the moment that you've set something down on paper or created something in a fixed form. When it comes to registration, trademark at the federal level, which is what we're mainly talking about today, trademark is far more expensive than copyright. I will often suggest that clients, if they want to copyright something, they can often do that themselves. Trademark is a little more complicated, and because of the non-refundable expenses involved, usually best to have someone do it for you. With trademark, in terms of length, as long as it's continuing to be used and as long as you continue to renew it, you can hold a trademark in perpetuity. A company can be using a trademark for decades, hundreds of years, as long as they keep using it and keep renewing it. Whereas with copyright, going forward there, copyright is good for the life of the author, which is the creator, plus 70 years. Dave, you can just pop those up. Right, so again, the difference is with trademark, as long as you're using it and pay those renewal fees, your business can have that beyond your life. If you leave the business to somebody else, those trademarks can still be maintained and used, again, for hundreds of years, whereas copyright itself will eventually go into public domain. As we continue now with trademark, under the law, there's not just registered trademark, there are common law trademarks. So if you have a logo, if you have a tagline, you have some kind of phrase that you are already using in commerce consistently, you have established trademark rights in that use. And that's what that TM symbol stands for. And this is just one famous example of Starbucks. Their logo is not registered. They've established its use in commerce and they add that little TM. Anybody can use that TM symbol. It's only when you register something that you start seeing that other symbol, which I'll talk about in a little bit, which is that R in the circle. But the TM, if you've got a logo out there that is yours and that you are using consistently in commerce, you have established common law trademark rights, and you can put that TM next to it. Basically, it's like planting your flag, saying, hey, this is indicative of my business, my products. So I'm declaring that this is part of my trademark rights. And along with that, especially when you're first coming up with ideas for your logo or your trademark for your business, this is sort of an outline or a chart that shows how trademarks are best protected. That is, that if you've got something, a name, and here's a few famous ones, that really have no relationship to what the work or the product actually is, that actually gives you stronger protection than a name that merely describes what it is that you do. And so coming up with something that's fanciful or arbitrary, over time, that becomes associated with a business or a product, and that gives it ever more stronger strength in terms of its protection, because it's become established very clearly with a certain business or a certain product or range of products. So just something to consider, especially if you're sort of thinking about what comes next or what you want to do in putting together a business plan or maybe some new branch or new product offering as a part of your current business. All right, moving on to registration itself and what's involved. So as I mentioned, there's also state registration. You can register a trademark here in Kentucky. It's a far less expensive process, but it narrows your range of protection. And so generally, if we're talking about registration, we're talking about federal registration. So when it comes to registration, the trademark the USPTO requires that you define in what area of commerce you use your trademark. In other words, it's not an across-the-board registration. That's what allows different businesses who are not in the same streams of commerce to use same or similar names. So you would need to identify, are you a brewery? Are you a clothing distributor? Are you selling ceramics or housewares? Whatever it might be, you just have to narrow down the classes of protection where you seek that protection. And once you identify those, it helps to define the scope of what your protection is going to be. Now, you want to be careful about that, those decisions, because the fee is non-refundable, and that application fee goes by the number of classes in which you are seeking protection. And Dave, you pop that up, it's $350 per class. So obviously, the more classes in which you are seeking protection, which may be perfectly legitimate for what your business is and what you need to do, obviously becomes a more expensive application as you multiply those different classes. And continuing with that, as I mentioned, different companies may use similar names as long as these are in unrelated industries. That's primarily if the name is not famous. So, with something like some of those names that we saw before, Amazon, Apple, Kodak, can't really make use of those names these days in other areas. So you have to be careful about that, because the test, if it ever comes to a dispute, the test is likelihood of confusion. In other words, if I'm using a name that is close or similar to another business using that same name or logo design or something like that, will the general purchasing public be confused? Is there a likelihood of confusion? And there are various subtests that go along with that test. But for example, and Dave, you can pop up the next one. A good example is Delta, where you've got Delta Airlines, certainly very famous, but there's also Delta Faucets, completely different business, completely different customers, and no likelihood of confusion between the two. That, the airline company is not selling fixtures, and the faucet company, they're not booking airline tickets. So there's not going to be a confusion there. You can find uses in different streams of commerce for similar or even identical names. But again, just something to be careful of. And so it's always wise, not just for yourself, but in working with an attorney, to do some kind of a clearance search, not only in the database of the Federal Register, but also just doing a deep dive into Google searching just to see what pops up, and just to know, as part of your due diligence, if there are any potential issues involved in using the particular trademark or design that you wish to use. And that way, you avoid problems going forward as much as possible. All right. So there are two types of applications. There's one based on current use, and that's the principal one, and one based on intent to use. And I'm going to get back to that one. I'm going to circle back to that in a minute. But continuing forward with current use, we have to be clear about who is the legal owner. Is it you as an individual? Is it your LLC? Is it your partnership? Whatever it may be, you want to have clarity with that. And particularly if you're a single owner, if it's a single owned LLC, you may want to consider putting it in the name of the LLC, so that if you sell the LLC, there's a transfer of ownership, whatever it may be, the trademark itself can easily go with that transfer, rather than having to do a transfer from you as the individual member, the single owner of that LLC. You will need to indicate the date of first use. That can be an estimation, doesn't have to be literal, but you'll need to indicate the date of first use. Number 4, you're going to have to indicate the class or the classes, as we discussed, bearing in mind that the application fee, the total of that fee, is based on the number of classes. And then we have what's called the specimen. this is your proof. That proof can be a photograph that is of the product. It can be a screenshot of your website, of the specific web page, but it has to show that the trademark is being used in direct conjunction with the goods or the services indicated by the trademark. That's to prove current use, and you have to show something for each class. So if you've got 3 different classes as part of your application, you would have to submit 3 different specimens. And these are not physical specimens. This application is all digital. It's all online through the Trademark Office website. And these specimens are uploaded as screenshots or photographs or PDFs, whatever it may be. Once the application is submitted, it goes into review by an examining attorney. That examining attorney is going to look, he or she is going to look at the scope of the application just to make sure everything is filled out correctly. But then they're also going to do their own review of the use of the trademark. And that attorney is going to look to see if there's any likelihood of confusion going back to that test. And one of 2 things is going to happen in the next step. You're either going to get an acceptance, which is great, congratulations, or you're going to get what's called an office action. The initial office action is not final. It is a non-final office action, which will indicate that the examining attorney has found issues with the application and indicates what has to be done to address those issues in order to achieve potential acceptance. It might be that you have to submit a new specimen. It might be that there are questions about how you're using it. But if there are real conflicts that the attorney finds that had not been found during the due diligence period, it could be refused. And that's why the due diligence is so important, because those application fees are non-refundable whether you're accepted or application is refused or registration is refused. So that's a very important step. And I will note that it sometimes can be 6 to 8 months after you apply before you hear anything. It's just the nature of the sort of the trademark application queue. There's a lot coming in, and there are only so many examining attorneys. In any case, once we get to acceptance, then what happens is the application is published in the Trademark Office's official gazette, and it sits in publication for 30 days. And the purpose of that is to allow outside parties, outside interested parties, to examine the record and to raise objections for whatever reason. If objections are raised, then that involves a process where you, the applicant, have to defend your application against those objections. Assuming that you win that dispute process, or assuming that no one objects, then your registration is issued and you are entitled to use the R in a circle next to your trademark. So as you can see, it's a very long process. It's a process that involves careful thought at the beginning, analysis and due diligence before you actually move forward with trying to register your trademark. And once the application is in, it's still something of a waiting period before you actually hear back from the examining attorney. And depending upon what that examining attorney indicates, whether it continues to move forward. And so really it can be up to a year before a registration will issue, if it is going to issue. Now, the intent to use application is essentially the same kind of process, the same kind of application, but this is where you are planning to use a trademark. You are still in the earlier stages of your business plan. But even though you're in that earlier stage, the application process, the procedure is the same. You have to supply the same kind of information. However, when you apply, because you're not using it yet, you don't have a specimen. So the application's in without the specimen, and there's no objection. You get back what's called a notice of allowance, which means that the trademark office is reserving your trademark and sort of holding your application until you actually use it. Now, there's a time frame in this allowance. You have an initial 6 months to actually start using it. And if you can't make that 6-month period, you have to file extensions, and you're allowed up to additional 6-month extensions for up to 3 years. And that's, Dave, you can pop that up. So you're allowed an addition. So basically, you've got 3 years, but bear in mind you're paying a fee each time you have to extend that 6-month period. And if you get to the end of that 3-year period and you've never started to use that trademark in commerce, you've lost all that investment because all those fees are non-refundable. So while intent to use can be a useful procedure in certain circumstances, generally I advise clients, hey, if you've got plans to actually use this trademark, I would get going and go ahead and get to using it in commerce, and then don't fiddle with, having to do the 6 months and maybe renew, because that can get you in trouble if it just keeps rolling forward. And I have had at least one client, maybe two, who just, for whatever reasons, were never able to go past never able to actually make use of their intent to use application because they hit the 3-year period with all these continuous renewals and lost their entire investment. Now, once you have your registration, there are post-registration procedures. So that first use, that first period of use, when you get your registration, you have to file between the 5th and 6th years following the registration date, what's called a declaration of use. And you have to show specimens proving that yes, I am still actively using this trademark and I am still actively using it in the same classes, the same categories of use that is associated with my registration. Now, following that, you have to file the same kind of declaration and a renewal every 10 years. Now, this is where if you keep filing every 10 years, you can have it in perpetuity. There are, Miller Beer, for example, they've been using the same logo since the 19th century. So that's been in use for over 100 years because they keep filing the renewals. So that is available to you. But again, you have to show proof with specimens that you are still using the trademark in the same streams of commerce. And the fees, again, are non-refundable. But the final point, because this comes up, businesses often expand their areas of commerce. They might start offering additional services, new categories of goods. That's all fine, but you can't dovetail on a registration. You have to file a new application to address those areas where the business has expanded in its areas of commerce. And so that's easy enough to do because your business or you own the trademark, you own the rights in which you have been using the trademark. And so you certainly have the right to file these new applications. But again, you have to be careful about your due diligence and still doing that search to make sure that no one else has maybe started using a similar logo or tagline in this area of commerce in which you are choosing to expand. Again, looking at the test, would there be a likelihood of confusion? And so that's really the scope of the concern with any kind of filing or additional filing like that. This is my website. I work with a lot of small businesses and individuals in the arts, but I've also worked with a lot of small businesses outside of the arts because much of the approach and the type of business issues that come up, whether it's an arts business or a non-arts business, they're very similar. But I urge whether you would reach out to me or reach out to someone else who practices in this area, I urge you to do so because certain of the clients that I've picked up over the years, they come to me after problems have arisen. And it is, as I always offer, it's always safer and less expensive to meet with the attorney first, because then you can get an idea of, well, here are the things to watch for. Here's the concern. I know we get very involved in sort of working on the branding and working on how the branding dovetails with maybe the mission of what it is we wish to do. But you don't want to lose sight of these other concerns related to your IP and how best to protect it and organize it going forward. So I would love to take questions. So
I'm gonna,
thought.
I'm gonna leave this up so everybody can see, but we do have quite a few questions here. Um, so let's see here. Um, it says, which one lasts longer, trademark or copyright? How many years do they last?
Well, it's like I tossed out, one of the significant differences is that a trademark can last forever if the trademark continues to be used in commerce and continues to be renewed with the trademark office. If it's a common law trademark, I mean, as long as you continue to use it, establishing common law rights, again, that can last pretty much forever. But with registration, if you want it to last forever, you have to keep renewing it. You have to be on top of that. Copyright lasts for the life of the creator plus 70 years. And then it goes into the public domain. So the significant difference there is, again, trademark potentially can last forever. Copyright can't.
Right. That reminds me of a question I do have. I've seen this with some companies and just recently with different beer brands, but they'll resurrect a brand that you haven't seen in 50 years. I mean, is that a viable way to do that? Could you just swoop in and look for old trademarks and take them over that way, or is there that? I don't know.
I mean, I'm not saying you couldn't try to do that. It really depends on what has happened with that old trademark during the intervening period.
Mm-hmm.
It is possible that there was enough use established with that old mark that somehow there may, even if the registration expired, that there is still some sort of common law trademark right still established with it, depending upon its relationship to how it was used before. So
Mm-hmm.
I don't know that I would say that there's a single answer to that question. I think it would come down to researching
Yeah.
the individual trademark and sort of seeing where its history, what was its history after it sort of faded from use.
Right. Let's see. Thomas asks, is a poor man's copyright a legitimate copyright
Well, yeah,
viability?
the short answer is no. Um, but
Okay.
but I want to clarify. The copyright comes into being at the moment of creation under copyright law. So when I sit down and I, write a story or create a design, I have copyright in that. But the rights that accrue to that would allow you to bring suit, bring claim that someone is infringing that copyright. You have to have registration first. You can't go to court without a registration, and the registration process is relatively easy and relatively inexpensive. You go to the Copyright Office's website. There's an online registration process that takes you through step by step. And the fee for an individual work is $65. For a group of works that are the same group of 10 works, it's currently $85. So the expense is more minimal compared to trademark registration. And so I advise people for whom the copyright in a particular work is important, is related to their creative work or their business, to go ahead and copyright it and get that registered, rather than just having it, especially if it's something that you're going to be putting out into the world, on the web, on a website. I would move forward with copywriting it.
Kim has an interesting question. She says, if I have a mascot known to the community for 23 years and it corresponds with an industry and another same industry starts, I guess another company in the same industry starts to use same likeness, but not the mascot, and they are using my name in part.
Sure sounds like infringement to me.
Yeah.
I mean, I say that casually. Um, I I would need, or an attorney would need, to review the particulars, look at the comparison of the designs, but certainly, given the facts as presented, it sounds like there's an issue there.
Yeah, I would definitely recommend that you talk to Jeremy or another attorney, get some information on that. So, Thomas says, is it okay to use a logo that is created using AI, or would I need to redesign the trademark?
Yeah. So, bearing in mind that all things AI are very recent developments, and that the law trails dramatically behind such developments. As things stand now, the Copyright Office does not recognize anything created by AI as being eligible for copyright protection. So if one is using AI as a tool, the next step is to take what that tool has offered and do what one needs to do to make it an individual creation prior to seeking registration with the Copyright Office.
Okay. Do you do patent searches also, services?
I do not. I do not. Trademark, copyright, trade secrets, that realm.
That's enough for one person anyway, right?
Yes, it is.
Let's see. Drew says, if you provide an in-state service, should you obtain just a state trademark or obtain a federal trademark too? That's a great question.
Fair question. I have had clients start, in that scenario, start with a state trademark, sort of just to get their feet wet. But if it's something that, with the idea that maybe those goods or services may expand beyond Kentucky and then move to a federal registration. But bear in mind that if the goods or services are being offered through the internet, I mean, the internet is worldwide, countrywide. So unless if it's brick and mortar and you're focused entirely on Kentucky, or even if you're on the web and it's really something about Kentucky, then sure, nothing wrong with starting with a state application and registration. That registration fee is, I mean, $10 to $15 these days per class, which obviously is far less than federal fees.
Yeah.
But it really comes down to the client and what their current basis is and how they hope to maybe expand.
Yeah. That brings me to a similar question. This might be silly, but if I own Dave's Lawn Service here in Kentucky and I hear of a Dave's Lawn Service in Arkansas, Can I ask them to cease and desist using my name, or is that ridiculous?
Yeah, no, you wouldn't be able to do that because Dave's Lawn Service in Kentucky is not going to be servicing lawns in Arkansas. And similarly, Dave's Lawn Service in Arkansas is not going to be servicing lawns in Kentucky. So it comes down to that test. Is there going to be confusion between these two um, services with the same name, but in these different geographic locations?
Gotcha.
Sometimes there are businesses where there might be that kind of confusion, but where there ends up being this kind of agreement that because we are in these different locations, people in Kentucky are not going to be confused by the folks in Arkansas and vice versa. And so those two businesses can come up with an agreement where they agree that they're going to use these two similar or the same trademarks, but in these different geographic locations. And they would make that known to the trademark office so that the trademark office would not see that as a likelihood of confusion because of the agreement.
Tom asked another question about, does it mean that if I start out with portraits and stationery and decide to add merchandising, I would need to register a new trademark along with the merchandising business?
It depends upon the scope of the merchandising business. The way those classes break down is, for example, there's a class for paper goods. So, if you had note cards or calendars or things like that that could fall into the same class or category, then you don't have to need to, if you end up expanding within the same class, you wouldn't need a new application for that. Because if you've got the class for paper goods, and when you start out, you're only selling a certain type of paper goods, but then you add to it new paper goods, because you're in the same class, you don't have to add to that. It's only when you start to move outside of those classes that you'd have to file a new application. And that gets down into particulars of your business. And you'd have to look at, what you're currently doing, what you plan on doing, and sort of see where you'd have to file a new application or not.
Yeah. Aprila says she wants to verify that trademark costs more than copyright.
Yes. Okay. Trademark costs hundreds of dollars more than copyright. Okay. Absolutely.
I think we talked about this, but Dallas says, can companies sue each other if they have the same name? Examples like Dove soap and Dove ice cream, for example.
Well, again, it depends. The test comes down to likelihood of confusion. So let's say you've got a company out there, Dove, selling soap. Well, if I started publishing books and I called it Dove Publishing, Dove Soap couldn't stop me from doing that because it's a different field, a different stream of commerce, and there will be no confusion. No one buying a book published by Dove is going to think that it's being published by the soap company. Now, that's just the name Dove. I couldn't make use of their design, which is associated solely with soap. That design, that's a separate trademark and also copyright. There could be copyright in that design. So if I'm going to have Dove Publishing, I need to come up with a new look and a new design. Yeah. But I can use the name.
Right. Do you have to register at the Library of Congress for copyright and trademarks?
Yes. Congress, the Library of Congress is the sole registry for copyright.
Okay.
But trademark, there's both registry at the federal level, at the Federal Trademark Office, and also the Kentucky State Trademark Office, again, depending on the scope of your trademark use.
Gotcha. Raleigh, hey Raleigh, says he does consulting work in Kentucky, but open to doing it anywhere. The name is Humankind Consulting, but I have seen Humankind HR or Humankind Consultancy. Is this going to be an issue?
That's a more particular question I or any attorney would have to research, bearing in mind that sometimes certain names, and I don't know if humankind would be one of them, certain names are considered generic enough with how they're being used that multiple companies across the country can use them without anyone being able to claim I'm the only one who can use it.
Okay. We have trademarked our business name in Kentucky, but are aware of another business in a different state, Minnesota, with the exact same name. We are a service company and they are a product supply business, but both in the same electrical industry. If we add a digital product business nationwide, would we have to change the name?
It's a fair question. And again, as we start to get into some of these more specific questions related to individuals, it really becomes there has to be research done into that question. And I don't mean that to suggest I'm trying to get business here. I'm just saying that there are specifics involved in terms of what the Minnesota company is doing, how long they've been doing it, what their product line consists of versus what you all wish to do, and where the line is between what would not be confusing versus what might be confusing. Those are questions that I or any attorney would need to research.
Yeah, yeah.
But it's a fair question, and you are right to be concerned about it.
Yeah, that's a great question, Melissa. So I think that's about all the questions we have. This has been fantastic, Jeremy. I mean, everything that you do and everything we've talked about is just so nuanced, and which tells me that there's a million ways to get in trouble with this thing if you're going to try to navigate it alone. And this may be one of those things where it's best to surround yourself with people that know what they're doing to help you get to where you want to go.
That's how I view it. I mean, especially with trademark.
Yeah.
Well, especially with federal trademarks. With the state trademark, I mean, if you go to the Kentucky Secretary of State site, the application is one page, and the fee is again, it's low. So that's certainly something that I think someone could pursue on their own if they wanted to. And copyright, again, is something that I often suggest to clients, just go check it out, see if it's something you feel comfortable with. Otherwise, I do those filings for people. But when it comes to federal trademark, the money involved is significant. And as you point out, there are places where you can trip up. And so I think it's best to have somebody help you with that.
Yeah, I agree. Jeremy, thank you so much for spending your time with us today on another Toolkit Tuesday. This has been really enlightening, and I encourage everyone to reach out to Jeremy if you have any questions. We will, a couple of days, send everyone the recording of this today, and we'll have it up on YouTube so you can watch as many times as you want. And so happy that you were here. Jeremy, thank you.
David, thank you very much. My pleasure. Good luck,
Janet?
everyone.
Yeah. Janet, thanks for driving the ship as always.
Sure thing. Just a reminder, everyone will see a separate email with a evaluation form, so that'll come separate from the slide deck and the recording. So keep
Yep.
an eye out for that for us.
All right. Well, thanks, everybody. Have a good Tuesday, and we will see you next Tuesday for another Toolkit Tuesday. Have a good day today.